Mr. Speaker, through you and to the members, I rise in opposition to this amendment. Let me begin by expressing my heartfelt sympathy for the tragedy that is this family's situation played out over the last year and a half. As much as we know about this situation, or we think we do, from what has been published in papers, published on TV, there are many, many other family tragedies playing out across Massachusetts involving children separated from their parents, when the standard we have to deal with is what is in the best interest of the child. And it is a process that plays out in privacy, because what is in the best interest of the child is not to have that process play out in the public. So the evidence does not become something we get our arms around as members of the public when this is playing itself out as an evaluation of what is in the best interest of the child. I could talk for the rest of the night about what a bad precedent this will set if we were to inject ourselves into this ongoing court case. I do not know what is in the best interest of this child, but I do know that when we follow the process of a mandated reporter that happens to be, in this case, employees of one of the finest hospitals in the world when it comes to children's services and health, making a report, and when that goes to the department, and the department conducts an investigation, and when it goes to a court, and the court puts the time in, and we have a very good judge in this particular case, rendering a decision, we have no choice but to let that process play itself out through the appeals courts. There are so many times that we find ourselves in conflict with the judgment of our court system and want to take some other action. There are so many times we find ourselves in conflict with the actions of our administration. Is there anyone who sits in this chamber who hasn't been called about a DCF action? Just twice in the last few months. I've had a mother who had a 10-month-old child that she adopted out of Pennsylvania, taken from her home because of an allegation regarding the husband who was forced to leave the house, the mother having done nothing, the child removed immediately from the home and taken back to Pennsylvania from my district. Now, what amazed me, to the point of some previous speakers, is the calm judgment of that parent under the circumstances, because I know how I would have reacted. I argued with DCF about that case. She got an attorney. She went into court. I stepped out. Should I have brought some action here to say, bring that child back to that home? And what about the grandfather who was wrongly accused, found not supported on a 51A, of abusing a niece, and as a result of that, cut off from the grandchild? And even when unsupported, DCF wouldn't remove the restriction until the DA said they were not going to pursue criminal charges. Well, let me tell you something about DAs. They never say they're not going to pursue criminal charges. That grandfather was cut off. Am I supposed to bring an action here? Am I supposed to bring a bill here to return that relationship? We set policy. We ask our administration to enforce that policy, and we ask our courts to judge the administration of that policy. We do not step in. No matter how compelling the emotion may feel, we do not step in the middle of a court case and take it away. We may decide at the end of a court case, as we've been told so many times by the SJC, if you want different outcomes, change the law. That's entirely and completely different. When we talk about setting a new standard, this judge didn't set a new standard. You take on this, you will set a new standard for action from which you will never, ever recover. This is a family matter before a family court that needs to play out through that family court. Please let this process finish. Thank you, Mr.
Chair recognizes Mr. Peterson of Grafton.